So back we go. I don't want to redo it all. Uh, we need to look at some of the illegal interference. This is part two of immigration and labor law. Employers, that's how I abbreviate it, ERE apostrophe ERS, can't engage in things like, I'm going to close the plant, or you're going to lose benefits you've already had. They can do some of that before the certification process begins or once this vote is in place. But once the NLRB says this, you've got enough workers here that are interested, let's put it to a vote, we lose, as employer, the ability to say anything negative. I've followed Coors kind of loosely over the years, and they've essentially been able to say, look, guys, we give you pretty much everything the union gives you, and you don't have to pay the additional dues, and you don't have the union campaigning for politicians you don't really agree with. Look at how the unions use your money. We deal with this. We deal with this like we're a union shop, but we don't have a union. And at least for Coors, it seems to have worked pretty well. And that maybe is the underpinning idea of unions, is kind of a local deal. The problem, as some people identify it with the union, is these big national organizations. And it's certainly, where the Teamsters and others have gotten themselves in trouble with people like Jimmy Hoffa stealing money out of the retirement plan, or, there have been some games played. I'm not going to go down that path. You can go look at it. You can look at whether nationalized unions are really a good thing. I will go down the path of, if you hate big corporations, why do you love giant unions? Doesn't make sense to me. It's kind of the same thing. But let's figure out, why do we need a giant union? We may need it because they're the ones who can play with a corporation that has, relative to the lowly worker, unlimited resources. We're still at this Jay Gould at the top of the economic heap. We can think that people like Rex Tillerson are above the fray, but I shouldn't be using names, but your average CEO lives on a much nicer piece of property, 5 to 12 acres on Long Island, than the average worker who's, stuck into a 2-bedroom flat in Brooklyn. Big difference between the two. So the unions also have some negatives that they've done: coercion, threats. They've taken guys and followed them home. There's all kinds of bad behavior. That's bad. If the unions are engaging in this, they may bust up the union. They may, as it says, if these occurred, the NLRB might void this election and set another, and make the parties live up to their agreement. This is meant to be open and clean. So, some of the rough stuff can occur before, if you will. But once we get in and we've got it going, leave it and let it happen. But you're always able to give information. You've got to be careful about how it is. Under the NLRB, you must be able to negotiate at least wages and fringe benefits. So example, we might be able to, on fringe benefits, retirement plans, work safety rules, healthcare plans, off-duty hours, all kinds of things we may be able to work on. I would say that work safety rules is another area that I didn't address earlier, where unions have really been very powerful. And this is where a lot of times the railroads, given enough experience with the unions, now recognize that the workers are really pretty interested in making the corporation great too. And, they're trying their best to say, look, we think this is wrong. Could we at least discuss it? always being at loggerheads when you're pretty likely to be in a union setting. If management is always at loggerheads with the union, it just creates a hostile work environment, to borrow a phrase from sexual harassment. You know, who wants to work there? You don't trust us, blah, 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 blah. We organized as a union because we do have some issues that we feel pretty strongly about as a group or as sectors of the larger group. Um, Under the NLRB, and this is something that I haven't done the research on, but you cannot have a closed shop. So I'm not certain why we have these right to work laws out there. I mean, workers always have the right, as I understand the law, to say I'm not paying the union. I've always got to now, even under right to work laws, we still have to pay the cost of negotiating the contract. That gets us pretty far off into the weeds, if you will, as to how we actually determine that. You just need to know, as both union organizer or union member or employee, there may be a way for you to get union benefit but not pay full union due. You know, should the employer be advising workers about this? Not if its intent is to bust the union. If it is doing, you know, it might be a best, don't say anything about it. This is a union shop. Do you want to join the union? And leave it at that. Here's a box for it. You know, maybe we can negotiate that inside the collective bargaining agreement, how we deal with that. That may be the best thing to do. Is that absolutely permissible? I have to say that's a little deep in the weeds for me. I'm not real sure. Can we discriminate against non-union workers while they're there, or discriminate against union workers? No. You know, once this, we need to treat everybody the same. We've got to use the CBU rules on seniority, experience, right to bid in and out of jobs. A lot of these jobs, that's how the unions tend to work, is I've got 2 years as a press operator. I want to bid over to XYZ. You know, I want to bid over to a linotype operator. Ordinarily, seniority determines this. But there are places where even in a union shop, we can go, no, you can't really do that job. We've got to test you first. But we can't really, as I understand it, discriminated one way or the other, that only the union members go to the top of the list. Everybody's seniority is the same. All right, union security agreements. And strikes and protests. Closed shop, that is, you must be a union member. To the best of my knowledge, this is illegal in the United States. There's been some amendments to Taft-Hartley and other things. You know, we can still have people who are not members of the union be part of it. And if you look at the average public education school, there's always 15 or 20% of the teachers who are not members of the union and really don't want any part of it. They're still allowed to work there and they still get the benefit of the contract, but they do pay some amount to it. A union shop must join the union in 30 days. That is legal. You know, so this is a union shop. If you're going to stay here, you must join it in 30 days. There's also the agency shop, must pay agency fee if don't join union. And maybe this is the area I don't really understand very well, is that essentially what the right to work laws do is they turn everything into an agency shop. You know, because I can see as I'm looking at this, if you can permit a union shop, you must join it within 30 days. Well, effectually, after 30 days, it's a closed shop. It's just that closed shop is you had to be a union member before we could even hire you. Strikes. These occur periodically, but they are much less frequent than when I was a kid and way lower than they were going on in the 30s and 40s. The 40s, there was a big railway strike, but a lot of it went by the wayside once we got into the war. That just got put on hold. But notice, if we're going to strike, we have to give our employers 60-day notice. And then that ordinarily forces us to the bargaining table. We'll see, if it's federally dominated industry, we may get forced to mediation before a panel of mediators or an individual mediator under the federal system. Oftentimes we can go to U.S. District Court if we need to begin to get the mediation process going, or the U.S. District Court can oversee the mediation. There's some wisdom in letting the U.S. District Court do this. I practiced enough in U.S. District Court that I came to a phenomenal, almost worship, if you will, of federal court judges. It's a dangerous place to go. They are kind of kings of a small community, if you will. But the people that tend to get appointed there are phenomenal. They are top skill lawyers. I, of course, can think of a few that I didn't think that much of, but for the most part, these were really phenomenal, good lawyers. Now, they had political connections, and some of them weren't fabulous, but generally, it's really a great place to practice law and a great place to have law applied to you. May not always agree with what the judge did, but it's right. If the strike is deemed to be illegal, notice employees can be terminated. And so this is a caution to any union. Make sure you're abiding by the law. Make sure you've dotted all the I's, crossed all the T's, that you've gone through all the steps in the collective bargaining agreement to a point where even mediation isn't going to work, but we've tried everything we can. One of the things we can do as an employer is, if there's a strike, we've still got the right to operate. And so there's a lot of crossover training, or, let's say the engineers decide they're all going to walk out, but the conductors decide they're not going to on the same job. Ordinarily, they will. They'll honor one another. They won't cross each other's picket lines, but sometimes that doesn't happen. There used to be a clerks union. There used to be, I think there are yard masters who are still in the union. People may decide, I'm a carman. I'd rather be an engineer. I'm going to cross over. Railroad's probably not the best example here, but as we're doing this, we may have, and maybe even a lot of times management runs these things. Now, what has all the railroads have quickly discovered is that management does not know how to operate railroads, doesn't know how to operate a locomotive. They have smashed so many cars. It's just incredible. And I shouldn't laugh at it. I'm sure people have been hurt, but I'm trying to laughing at management's thinking, this is easy. Running a locomotive is one of the hardest jobs you can ever have. There's so many little subtle things that go into it. But I think we need to recognize, for workers as well as for the employer, there's no guarantee the same job will be yours. We may hire everybody back, but we don't necessarily have to put you back in the same job you held. We may be able to leave that person in based on a performance metric, particularly if they've got more seniority under the agreement. So, I've heard a lot of workers who engaged in a strike come back later, find their job filled by somebody else, and then them not able to bid on the job because the person who held it actually had more seniority. Do I have specific recollection? perfect, but I remember guys going, man, I didn't even think about that. So we need to think about that. Sometimes the union wants to make your workplace a show place for the nation. Well, it can have an individual impact that you guys need to be careful about as you're going there. If there's picketing, the employer has a right to limit your access to the employer's workplace. So the employees cannot, or the picketing individuals cannot block access for employees, customers, suppliers. We can set up an informational picket line, but you can't say, oh, you're not getting into work today, district chairman or, district foreman. No, you can't do that. They've got a right to come in. Even union members who should be on strike don't necessarily have to go that way. They can decide, I'm crossing the picket line. We can't stop them. And if we engage in violent activity, if somebody decides, I want to be what they call a scab, they've got the freedom to be a scab. All right. And maybe this is where people, because a guy with 19 years seniority may go, I can't do this. The union money isn't strong enough for me to pay the mortgage. I got to pay the mortgage. I got to pay the babysitter. I got to pay the private school tuition. I'm still going to work. I don't agree with this strike. I'll go in. So if the picketing people engage in violent activity, the employer or the affected people can go to court, gain an injunction, and maybe have this strike declared illegal, in which case we go back. So it's no good. The area of secondary boycott or picket, suppliers and vendors, unions have become loath to engage in this, but periodically they'll go after Walmart. You're a supplier or vendor. The caution I have on my slides, I think, is one we need to look at. Don't buy children's toys. You've got to be real specific. Don't buy our product, as opposed to don't buy any toys, don't buy any smartphones. If we're only picketing Apple, we can only boycott Apple, if that makes any sense. So my experience, unions are a little reluctant to go there. The kind of, the mindset, if you will, of the workers in the 30s, 40s, 50s, and 60s has slowly begun to disappear as we've become a more gentrified and more service-oriented as opposed to a more manufacturing or labor-oriented society. Not that service is not labor. It's just not the same kind of stuff as a lot of why these unions appeared, because of the vast difference between what happens to ordinary laborers against people who are higher up and pushing paper for a living. All right, now let's shift to a different topic, but one that sometimes the unions, if we look at the election of Trump, there may be this sort of mythical idea that the immigrants have stolen my manufacturing job, or it's these foreigners that have done it. This is going to more slowly unwind, and I don't want to keep a permanent state out here. But let me make a point, if I may, that what I see developing, and I'm doing this March 2nd of 2017, is very similar to what President Trump said in his speech, that we want each nation to be sovereign, that we want each nation to act under the law as its own best friend. And that's how we're going to have the U.S. act. And so we're going to try to go free trade. So I don't know if I can put it better than this. I think he's asking Mexico to quit being my kid sister, stand on your own 2 feet, and, assert yourself, and do the rule of law to help your own people. And so I need my book in front of me, I think, here. Because I'm not sure what 3 plus 3 yields as green card. H-1B, foreign guest worker visa. These are usually given out. All right, so let's go into immigration. You know, what we have, from what I can gather, is a law written in around 1898 that's just been tweaked around the edges. So Congress has successfully kicked the can on this for 120 years. We did a mass pardon, no, what's the right term? Amnesty for about 3.5 million. You know, the language at the time was mostly Mexican, or all the illegal immigrants were, oh, we'll just welcome you in. And then we're going to fix the law. Well, of course, they welcomed everyone in, but didn't fix the law. So, you know, we basically kicked that can for 30 more years now, and they're still fighting over this. We do have H-1B, foreign guest worker visa. This is oftentimes skilled workers. You know, so this is somebody who has a certain skill. A lot of hospitals, universities, and, you know, a lot of Silicon Valley is filled with H-1B, a foreign guest worker visa. A lot of times these are limited, a year or two. H-4, you may be able to come to this country because you've already got a family member who's here and you're important inside that family member's situation. If you're here 3 years of good behavior and then you do another 3 years, you may be eligible for a green card. I don't know that I got this right, and I'm not going to pause here. But someone who has a green card has a right to stay here, but it may be limited by time. So as we're an employer, and there's some real movement on E-Verify, you know, are we going to work more on a passport basis, where I, as an ordinary citizen, have to get a passport and I have to display it and be able to have it scanned in order to work at places. I'm a little bit in favor of that because it does have a lot of encrypted material. You know, when they scan my passport at the airport, and that's what I use. I don't use my driver's license. I fly with my passport because it has everything on it. You know, yeah, I'm giving up some privacy, but it's stuff they've got on me anyway. Green card does not mean you go into the front of the line to become, or maybe what it is, it's 3 years on a green card and then 3 more years, and then you're maybe eligible to begin the naturalization process. But it doesn't necessarily guarantee it. The one below, EB1, sciences, arts, education, business, or athletics, can be a 5-year path to citizenship. So, you know, great baseball player like Albert Pujols, if he were born in the Dominican, could eventually become a citizen of the United States. You know, I think our primary target is the first few, science, arts, education. These are the kind of super citizens. While we're on this path, you know, let's look at what it says on the Statue of Liberty. I don't know that the poem that is engraved on there was written before the French gave it to us or at a later point, but it does say, tired, poor, huddled masses yearning to be free. One of the things the United States, as a light, you know, the kind of glowing candle of greatness, international glowing candle, is we need to welcome in the huddled masses too. Now, do we need to bring everybody in? Oh, that's the hot button right now. And, you know, when we do the math on it, there's only so many people we can really get into, you know, that can let into the country. How many illegals are there? I've heard people like Ann Coulter say there's 30 or 40 million. Ann Coulter, I always take her with a grain of salt, although on the right, people, oh no, that's Ann Coulter, she's right. I don't know. Um, but there's probably 10 or 11 illegal immigrants here. For me, the word illegal means illegal. It doesn't have any other meaning. It doesn't have, feel sorry for them. I feel sorry for everybody who doesn't live in the United States. But it doesn't necessarily mean that they have a right to come to the United States. There's only so much work. There's so many benefits. Is Australia bad because it really watches its borders carefully? New Zealand a terrible place because it does that too? Let's have the debate. Let's not just call me a hater because I raised the question. So we should look at, and one of the things that's not being enforced is, at least as heavily as it could be, penalties for employers under the Immigration Reform and Reconciliation Act of 1986, 31-year-old law. When we did all this stuff, you hire them, we will punish you as employer. Well, we're not necessarily doing that. And some of the stuff we're seeing in the sanctuary cities is the old states' rights nullification arguments given by the South against tariffs, but also against you can't get rid of slavery. Wait a minute, folks. You don't want to adopt something like that, it seems to me. That's a states' rights issue that the states have the right to tell the federal government, whose law is supreme, that they can thumb their nose at that law. Not probably a very good idea. So anyway, luckily that's it. That's the end of my rant. I hope that was helpful. Take care, everyone. Bye.